Hi, my name's Andrew Prendergast and I'm Senior Partner over here at White Dalton Motorcycle Solicitors.
My name's Gavin Gruhl and I'm the Managing Partner.
In this episode, we are going to be discussing the truth about animal accidents.
Now, why is that relevant to us bikers? Well, if we play this video, you'll see how it can become very relevant to us. Should we start with the criminal side of things?
Yeah, so if you can see the video that's been playing there of the poor chap hitting the dog, poor old dog to start off with,
Yeah.
poor old man on bike.
Yeah, and I'm a dog lover, so it's especially difficult to see a dog being run over by a GSA of all machines as well.
It's a bit of a lump, to be perfectly honest, to hit it. Anyway, but luckily everyone walked away from that. It was one of our cases that we've dealt with. But the reason we're showing the video is because if you're involved with an animal in an accident, there's a couple of things you need to be aware of with regards to the law. So I suppose if we start with the criminal side of things.
Yeah, the criminal side of things. So if you have an accident with an animal, there is a list in the Road Traffic Act which sets out what you must do. So I'm going to read it out very quickly. If you collide with a horse, cattle, ass, mule, sheep, pig, goat, or a dog, you have a legal obligation to stop and report. Now, what do I actually mean by that? If there is someone nearby who is the owner of said animal, you've got a duty to exchange information with them. If there is no one around, so in this dog case, there was no owner to be seen. There was just...
And you can't talk to the dog, stating the obvious.
Clearly, you need to go and report it to the police because it is something that you have a legal obligation to do under the Road Traffic Act, and that can be found at section 170. So, I mean, if you fail to do it, there are ramifications.
It's super serious. So with regards to failing to stop and report, it's a super serious offence. And if you fail to do it, and so in this case, if the biker hadn't reported it to the police, he could get prosecuted and sentenced for failing to stop and report. The punishment ranges from sort of 5 or 6 points at the lower end, up to 26 weeks in custody at the upper end. And weirdly, it's one of those ones where it's an unlimited fine. So some other road traffic offences, it might be capped at £1,000 or whatnot. But in this one, it can be a mega fine if you haven't gone and stopped or reported an accident after hitting an animal. Now, just on the animal front, Gavin read out the lists that are prescribed in section 170 of the Road Traffic Act. But weirdly, cats aren't on there, for example. So if you hit a cat, you can just drive on past. It sounds horrible, but the law doesn't require you to stop and report it, which is weird.
Or a hamster, or a fish.
I mean, a fish, to be fair, if there is a fish had been dropped from a golden eagle, and you'd hit that in the road, you don't have to stop and report it. But I think...
Or your bike's at the bottom of a lake.
So what if you run over the koi carp in the bottom of a lake?
You just crash in a lake.
We've gone off on a tangent. However, so is clear, those list of animals Gavin gave are the ones you need to stop and report for. Anything outside of that, you don't. It's weird, but that is what the law says. So I think we've kind of parked the criminal bit there. And just look at that video that we had playing before. Obviously, you've got the criminal aspect, which we just talked about, and then you've got a civil aspect.
Yeah. Let's delve into the civil.
Yeah.
So this is not meant to be a step-by-step guide. We haven't got enough time to talk about it. So we're going to give you an overview of some of the potential causes of action and then delve into them with some detail.
And I think it's probably, on that point, this is not meant to be a law lecture because it's super complicated. And I think the law around this, I think one top judge referred to it as opaque. So it is difficult to get your head around.
That's how I'd refer to the Animals Act. One thing we're going to talk about, it is opaque. It is difficult to navigate. Before we get to that, shall I talk about occupiers' liability? This is normally relevant if you go onto someone else's land and you are bitten by an animal. The example that comes to mind straight away is a postman, goes to someone's address, dog comes bounding out and bites you. There is potentially a cause of action under the Occupiers' Liability Act. Now, not really relevant for us bikers unless you're a Deliveroo rider or an Uber Eats rider. So I'll park that there because most accidents will happen out on the public highway, not on someone's private land. Which
turns us across to the two other possible ways you might be able to bring a claim if you have an accident with an animal on the open road, as it were. So one is negligence and one is you might be able to bring a claim under the Animals Act. So we'll start with negligence.
Yeah, the common law. So common law is developed over many, many years and case law is important. I have to say, it's difficult. Some people think as common law as a catch-all and it's a safe pair of hands. It's not always that easy.
No.
So I think when you've got examples of a dog walker has let their dog off the lead and it's bounded into the road, that you probably have got a claim there because they've got a duty to make sure the dog is not going to cause anyone any inconvenience. And if it runs that into the road, then it probably has. So types of cases like that will be caught by common law. We're going to talk later on about a cow case, which unbelievably wasn't captured. So we'll come back to common law and those case examples. Should we go to the Animals Act, or is there anything else you want to mention about?
Well, just on negligence, to kind of get your head around negligence, it might be the fact, a man or woman has a farm, haven't kept their fences in good repair, and the horses wander out into a motorway somewhere. So they might be negligent in not keeping their fences sorted out properly.
Repair. That's a good example.
So that's one example of the negligence type action. And then the other one is the Animals Act, which is where we're now going to try and give you a brief overview of, because as I said earlier on, the law is opaque. So it's the Animals Act 1971. And so it's basically an act that is a piece of law that allows damages caused by animals to be brought. That's basically the general gist.
Yeah, it tried to consolidate, I think, many years of law, but didn't do a very good job of it.
No, the draft of it, Section 2, is the one that you'll be looking at if you've had an accident with an animal most of the time, but it's proper vague. So that act itself, before we talk about Section 2, there's two sort of categories of animals. So one is dangerous species, sort of like your lions, your tigers, your elephants. I mean, I'll be honest, we haven't had a case involving an elephant yet, but if you do have one, give us a call.
I mean, that would be a video, wouldn't it? Like a biker just having an off with a tiger.
Yeah, I mean, to be fair, it would do great for our YouTube numbers, but we haven't had one yet with a lion or a tiger.
You wouldn't want to be the rider, would you, involved in a collision with a tiger? No, that's going to be a bad day out.
So the more common one is the second section, the non-dangerous species. So your cats, your dogs, your horses, that kind of thing. So that's the Section 2.2 of the Act, is where you'll be looking, or your lawyer will be looking if they need to bring a claim on your behalf for that kind of thing. And I mean, I'm just going to read through and I'm going to go to my notes on this because you got to be clear what it's all about. So you've got to be going, the animal's behaviour that caused the damage was likely to cause the damage. So you need to prove that. And you need to prove that the likelihood of the damage or its severity was due to the characteristics of the animal, which are not normally found in animals of the same species or are only found in certain circumstances. Are you keeping up? It's weird language.
Hard going as well.
And the owner had knowledge of the animal's specific characteristics that caused the damage. And towards the end of the video, we're going to talk about a horse case where you suddenly go, oh yeah, the owner would have never had knowledge of that problem that could have caused that accident. And they were found not to be liable, even though someone got hurt when the horse bucked and the person fell off. So that's the brief overview of the bit you're probably going to be looking at if you have an accident with an animal and the Animals Act apply. But there are some defences as well, Gav.
Yeah. The Animals Act also lists some statutory defences. So someone looking to defend a claim brought under the Animals Act can literally go to that aspect of it. And I'll run through a couple because there's some good examples out there. So the first one is given as wholly the fault of the victim. And there's two cases, one called Dessie and West Midlands Police and another one called Nelms and Avon and Somerset Police. Now, they involve police dogs, also known as land sharks.
Which I never knew that phrase until today. I didn't know that police dogs were called land sharks.
I mean, you don't want to get on the wrong side of a police dog.
To be perfectly honest.
But that's what happened in these cases. So we've got a case involving someone kicking out at a police dog. And when he tried to bring a claim for getting bitten, the courts went, no, you're involved in goading the animal. So the fact it bit you, you can't then bring a successful claim. Right. There is a defence.
Rightly so.
And in Dessie, again, it was someone hiding up, had run from the police. They were given multiple warnings to come out, else the dog would be released. They didn't. Dog was released and bit them. And they could not then bring a claim because there was a defence.
So just on the motorbike side of thing, applying those principles, if you sort of came up behind a horse and you see people doing silly things in videos that people have posted online, if you've come up behind, say, a horse on the road, revved up the engine, being an idiot, and the horse has then bucked and kicked and knocked you off your bike and caused you to get injured, unlucky, you've got no claim because you basically caused the problem yourself.
Yeah.
You can't rely on the horse then bucking on the highway going, oh, I've got hurt now. So that's a kind of
that's a good example of wholly your fault. Yeah. And I think a lot of us shared space. I know you do some off-roading, but you come across horse riders. A lot of people have got the sense to cut the engine, wait.
If we're out Green Lane and on our bikes, we always pull over. It's easier for us to pull over our bikes, like 3 or 4 of us in a group, turn off the engines, and sit there and wait for him to go past. I mean, I've only ever had one horse properly spooked and take off, but we'd got ourselves out of the way, made sure we were in the clear, and this particular horse was jittery, but we were fine and safe because we hadn't tried to push through on a green lane. So that's an example of that.
Well, actually, that brings me on to another defence then. So there is a statutory defence for a voluntary acceptance of risk. And I have to say, this normally applies for horse lovers or people that go out riding horses.
Yeah.
Is there an element of danger or risk in riding a horse? There is. And there is a defence in the Act that if you accept that risk and then you fall off and have an accident, you can't then bring a claim. Similar for bikers in a way, because riding bikes is risky activity.
Can be, yeah. But with regards to the sort of animal interaction, I suppose if you were out perhaps doing an event on your bike, there's some horse events where they get bike riders involved and stuff, might apply there. But most of the time on the road, you're riding your bike. It's not like riding the horse where you've accepted the risk. I mean, there's a case out there where someone had wanted a particularly lively horse to go riding across the countryside on, and that lively horse had then thrown her off. And the judge said in that case, no, you've got no claim. You accepted the risk. You were going to ride a jumpy, lively horse, and unfortunately, you fell off. So unlucky.
And that risk has come to fruition.
Yeah.
There's an example given here of signage. So if I go back to the Occupiers Liability Act, if you go onto someone's land and there are signs saying loose dog, stop, don't enter, there can be an implied term that you've accepted the risk by venturing on when it's clearly signed. So something like that might act as a defence.
So if you were perhaps a rider going into a farm calf or onto someone's property, that sort of thing is what you're talking about.
That's right, yeah. And you're on knowledge and they've given you the warning. Yeah.
But I mean, most of the time, these sort of things don't really apply with the bikey side of things. But you've got to be aware of it. So what we're saying is the cases are so varied and the law is so opaque. I mean, just taking on to that, just tell us about the horse case we mentioned earlier on the video.
Yeah, so there's this, I guess what we're driving at, it's very fact dependent. So this case we're talking about, Ford and Seymour Williams, the horse sadly suffered an illness, so a cardiovascular issue.
Yeah, that's what they think it was.
Yeah. And the horse has fallen, caused injury as it's gone down. And if we go back to the Animals Act, part of that was you need to have knowledge of the animal. And the court found that the owner, the keeper, did not have knowledge that the horse had this illness, this sickness, which resulted in the cardiovascular issue, the horse falling and causing injury, and there was no claim because there was a failure on that part of the Act.
So it's really fact dependent is what we're trying to sort of hammer home the point. And just on the owner, the keeper point as well.
That's a really good point. Yeah, so it's not as easy as one might think. The Act talks about the keeper of the animal being liable. It's a good point you mentioned there, because who is the keeper? The court makes reference to the head of the household. So if a child keeps an animal, and
the family pony or something, the kid's pony.
But it would be the keeper, so the head of the household, which is a really unusual term that's only I've seen in the Animals Act. It's very fact dependent. So there was a case involving a farmer who rented out his farmland to keep houses and took renting from that. But he was not deemed to be the keeper of the animals. He was simply the owner of the land. So any claim against him would fail. Rather, it would have been the keeper of the horse who lets it graze on the farmer's land.
And you had that exact point in your case where the horses had escaped onto a dual carriageway and caused an accident.
Yeah.
But the horses weren't actually owned by the keeper. The keeper was a person who was renting out their particular stables. Different to your farmer example there, they were actually charging to basically look after these horses, so other people would put them on their property. They were in charge of them, they were the keeper, and then the horses, because they had fences and whatnot in good order from memory, they've escaped. And so we didn't go after the owner of the horse, went after the keeper, the person that was renting and getting paid to look after the horses.
Yeah, so very fact dependent. Which brings us on to the cow case that we mentioned at the beginning.
So the cow case is a case called McKenney and Foster. So this is just an extraordinary case, to be perfectly honest, where you would think, well, yeah, I'm definitely going to be successful here. So let's just start at the end. The end of it was a poor cow has wandered into the road and there's been a car accident. So person's hit cow, and had an accident. So you go, well, surely the farmer's liable for that because, he should keep his cows locked up properly and be aware that these could wander out onto the highway. But what they did in that case is they're looking at the knowledge, really, of the owner and what had actually happened. So facts-wise, Basically, this cow had clambered, and I'm just looking at my note from the case at the time, had clambered over a 6-barred livestock gate, so one of the big gates you see in the countryside, made its way down a lane. I love this part of it. It either tiptoed, and I'd like to see a tiptoeing cow, but it tiptoed over or jumped over a 12-foot cattle grid. And then it was agreed that basically this particular cow had become extraordinarily agitated on being separated from her calf, which importantly was out of character for the breed for that and that cow. So you're looking at the character of the cow, character of the breed, and what actually happens. And so because this cow had been weaned off her calf, or the calf weaned off the cow, perhaps the other way around. Anyway, so they've been separated, and this cow's got agitated, and then it's gone on the Great Escape, which I'd argue is probably better than the film. Whilst I love the motorbike jumping over the fence, iconic as a motorbike fan and an old films fan, I'd love to see a tiptoeing cow. So you'd think, well, what happens? And it turns out that unfortunately for the person that got injured on the road, no claim. This is because, and I'll read the note, because the behavioural characteristics relied on the claimant agitating resulting from the cow's normal maternal instinct upon being separated from her calf was neither dangerous nor causative. Okay, which is what we're talking about, difficult areas of law. And the dangerous and causative behaviour was exceptional and exaggerated agitation resulting from the cow's maternal instinct, which was not normally, but crucially not known to the defendants, so not known to the farmers. And neither this cow nor the breed were generally known to exhibit their maternal instinct with such excited and exaggerated anxiety. So that went all the way to appeal. Appeal lost. Person who got injured had no claim. So that's what we're saying when it's fact dependent. You got to look, the characteristics of an animal, the knowledge of an owner, and then try and work out whether you've actually going to have a successful claim. Hence why there's so many cases reported over the years.
Well, so many failed cases under the Animals Act, because it really is a difficult piece of law to get your head around.
There we are. So that sort of brings our overview to an end. We could spend hours trying to explain the law. This isn't meant to be a law lecture, as we've said before, but it gives you an idea about if you're involved in an accident with an animal, you need to get some expert advice because it is a really tricky area of law.
Yeah, I'd agree with that. Hope you've enjoyed the video. As ever, if you could like and subscribe, please do leave your comments below because we do read them. And if you've got any follow-up videos, they will be a follow-up to the comments put below. And we will see you on the next set of videos. Thank you.
Thank you.